Hello everyone and welcome to today's webinar, Achieving GDPR Compliance in Local Government. My name is Simon Merrick and I'm excited to be co-hosting this webinar with Alan Calder, who's the CEO of IT Governance Limited. Alan is a leading author on information security and IT governance issues and regularly talks and commentates on governance, risk and compliance issues. And for my own sins, I'm leading Agilisys' GDPR and Cybersecurity Advisory Services. Today we're going to be discussing the impact of the General Data Protection Regulation principally on local government in the UK. I hope it will be clear that through the majority of the impacts that we discuss, they certainly apply to other public and private sector organisations. Just a bit about why we brought IT Governance and Agilisys together. GDPR compliance should not just be seen as a compliance issue. Unlike PCI, DSS and other sorts of regulations, this is a transformation opportunity that affects all organisations. And it's not just a one-shot thing like those who remember year 2000 was. This is going to be an enduring regulation going forwards. I think as the ICO puts it, to truly comply with the spirit of the regulation, and for organisations to gain a competitive edge and run as efficiently as possible, at least from a data perspective, personal data perspective, there is a real opportunity here for organisations to understand through the collection of that data how they're interacting with their citizens and customers. And gathering personal information in these days, digital age, is very easy, but truly respecting that actually it isn't yours, even though it might be sitting in your data centres, means deploying a broader range of skills to protect and process it lawfully, fairly and in a transparent manner. And that's not really just for the IT, legal or data protection people. Just to bring this all into focus, from today's organisations have just 227 business days left to implement changes that they think they need before the regulation and enforcement is applied. We are currently in a transition period, a grace period if you will, right now. And knowing from my own experience how long it takes to put corporate systems in, once you start talking to everyone, get all the processes sorted and systems in place. If you haven't started the transition yet to compliance, this number should give you a little bit of panic. So before I hand over the mic to Alan to talk and settle that panic, I have a few housekeeping items just to cover about the webinar. It's going to be available on demand after this live session, and it's also going to be accessible from IT Governance's website. Everyone is going to be muted during this session, but if you do have any questions during the webinar, please do type them into the questions function available in the control panel as we go. And at the end of the session, myself and Alan will try to answer your questions. The slides and the recording will be emailed to you tomorrow as well, so no need to take notes on what we're covering. We've also added some self-help information, some handouts as well in the panel, and places where you can go to if you think the organisation needs help complying with GDPR. I'd say please do contact Agilisys so that we can help make sure that you've got the right mix of services. And lastly, I'd encourage you to share today's webinar with your social network. So without further ado, I'd like to kick off things by welcoming Alan. Over to you.
Good afternoon, ladies and gentlemen. I hope you're still there. This is Alan Calder, and today I'm going to be talking for the next 35 or 40 minutes about the impact of GDPR on the processing of EU residents' data, the effect of Brexit on data protection in the UK, the role of data protection officers, particularly in the public sector, the way in which local government have to go about meeting their compliance requirements and how the identified 9-step program can get you there, a brief look at relevant tools and processes, and of course particularly at some of the issues around breach notification, which is so fundamental to effective GDPR compliance. Starting with the impact of processing on the data of EU residents, the key changes from the current Data Protection Act, of course, is that the requirement to appoint a DPO is mandatory in 3 specific circumstances, one of which is for public authorities, a second is accessing large volumes of either personal data or, in the third case, sensitive categories of data, special categories of data on a large scale. So that's mandatory. Reporting data breaches is mandatory. Of course, in the public sector in the UK, it's been an administrative requirement for a number of years now. It becomes a legal requirement on every single data controller across the European Union, and the requirement that data protection by design and by default is fundamental to organizations' approach now shifts from being a good idea to being, again, a legal requirement. There are a number of challenges in demonstrating compliance, starting with the requirement to demonstrate accountability. Accountability starts at the top of an organization, and the way in which accountability reflects through the organization will of course turn up where there's a data breach, and the Information Commissioner will be looking at the levying of fines not just on the basis of the breach itself, but on the extent to which the breach demonstrates an absence of or adequate accountability throughout the organization. So you're going to need, as part of your compliance journey, to deal with a whole set of changes in jargon, in shifts in documentation requirements, and the need for proper administrative and evidential documentation, but it's accountability that's the core of it. And while there are obviously going to be derogations, GDPR provides for very specific derogations to member states. Not all of those derogations are yet in place. They may only come in up to or beyond May next year, so you're going to need to keep an eye on changing requirements in those specific areas. So starting with the scope of GDPR, that's about material and territorial scope. GDPR protects natural persons, not legal or incorporated persons, not therefore dead persons, but natural persons, and it protects the rights and freedoms of natural persons irrespective of residence or nationality. So if you're if you're an EU public authority processing the data of somebody who happens to live in Turkey, they're entitled to exactly the same rights as are the citizens of the United Kingdom in terms of how their data is processed. Natural persons have rights around how their personal data is protected, how it's processed, and to unrestricted movement of that data within the European Union. And a bit like the Data Protection Act, it covers all data irrespective of whether it's in analog or digital format, paper, telephones, voice. All of that is personal data. As long as it's going to be used in a structured filing system, it will be caught. In other words, if you've got a pile of papers in the corner, you have no idea what's going on, those would be outside scope. But if it's intended to be part of a structured filing system, that's within material scope. The regulation goes into force in all member states as written, unlike a directive which depends on enforcing or enabling legislation in member states and which allows for interpretation. A regulation doesn't. It goes into force on the same day in the same way in all member states, and in theory is enforced in exactly the same way. And you can download a copy of GDPR from that link you see on the bottom of the screen in front of you. It'll be on the slides, which, as Simon said, will be sent out tomorrow. It's worth reading. It's written in good, clear English. It's also written in good, clear any one of the other official languages of the European Union. And it is in force now. It will apply, and therefore breaches will be capable of having actions brought against you from the 25th of May next year. There's no change in that date. There's no transition beyond that date because we are already in the transition period, and we are in fact somewhat over halfway through the 2-year transition period. So this is not something where you want to wait until May next year before getting to work. You need to be at work already. There's a substantial amount of work to be done to get yourself compliant. And you need to bear in mind that amongst the ways in which the regulation is enforced are initially the right of data subjects to bring actions against data controllers as well as against the supervisory authorities, and they can do that in the courts where data is being processed, where you're based, or in their home state. And any person who suffered material or non-material damage has a right to receive compensation from controller or processor, and that of course means that there's every likelihood there will be a substantial body of people suddenly discovering that they've got a number of things about which they feel that they've suffered non-material damage and about which they bring complaints. And so if you consider that in the normal group of people that any data controller or public authority in the UK is handling, there will be a number of people who are likely to feel themselves upset. The possibility of cases being brought is very substantial. Alongside the costs of handling and the costs of awards arising from those kinds of cases are fines that can be levied by supervisory authorities up to a maximum of 20 million euros or 4% of total turnover in the preceding financial year. And the fines are linked to particular types of transgressions, and the maximum levels of fines are applied to transgressions of the core requirements of GDPR, the principles, data protection principles, the rights and freedoms of natural persons, and the transfers of data outside the member state. There are going to be some provisions around public authorities and how fines might be levied, but at the moment the logical starting point is to assume that fines will be levied on public authorities in the same way as they will be on private companies and third sector organizations. Article 11 of GDPR requires data controllers, and both controllers and processors are clearly defined for the first time in legislation to facilitate the exercise of the rights of data subjects. And those rights include the right to consent, other than where there is some other legal or lawful basis for processing data, the right of access to, rectification of, erasure of, or what's sometimes called the right to be forgotten, the right to restrict processing while arguing over whether the data is correct or not, and the right to object to processing where the lawful basis of processing is something other than consent. Data portability flows from the logic that inside the European Union there should be no barrier on the free movement of peoples or information, so data subjects are entitled to get any information which they've provided in a machine-readable format and send it on to another service provider. They, as I said, can lodge complaints, and they're certainly entitled to know about any automated decision-making, including profiling, as well as the anticipated consequences of that profiling. I mentioned the principle of accountability, and what that really means is that across the 6 data protection principles, you'll remember that the Data Protection Act has 8. This is reduced to 6 under GDPR because the principle that used to cover rights is now a single chapter in GDPR, and the principle that was extraterritorial transfers is also now a separate chapter in GDPR. So we're down to 6 specific principles around the protection of rights and freedoms of natural persons, and what's really called the 7th principle now is the idea that the controller should be able to demonstrate accountability in how it's gone about ensuring that each of these 6 principles have been properly thought through and applied to every act of processing of personal data. And please bear in mind that the definition of personal data is extremely broad. It covers biometric, genetic information. It covers online identifiers, usernames, anything that can identify a natural person. There's no distinction between something that identifies a natural person in their business environment than from their home environment. They're all caught in exactly the same way. Personal data has to be secured against accidental loss, destruction, or damage, but in the first case it has to be processed lawfully. And lawful either means that you've got explicit consent from the data subject to process the data, or you have another clearly identified lawful basis, which might be compliance with a legal obligation or some other legitimate interest. It's almost impossible, following recent guidance from the Information Commissioner, for a public authority to rely on consent in relation to the processing of data of citizens to whom it has to provide by law specific services, and so one of the key areas that public authorities will need to look at very quickly is the whole basis on which they're processing data. Technically, if on the 25th of May next year you don't have a valid lawful basis for processing the data of any data subject, you need to cease processing. At the point that a data subject can demonstrate you're processing their data unlawfully, they're entitled to require all of it to be deleted, and those are the kinds of technical consequences one should want to avoid. Bear in mind that something which would be lawful on the 24th of May 2018 could become unlawful on the 25th of May 2018, but not necessarily the other way around. So it makes sense to get data processing into good shape as quickly as possible so your transition can be carried out clearly. Data subjects have got the right to know what you're doing with their data, so they've got a right to access the data. You can no longer levy a £10 fee, and the period within which you've got to respond is now 1 month. Not 30 days or 40 days, but 1 month. So I'd assume a data subject access request lodged on the 25th of May has to be fulfilled by the 24th of May, by the 24th of June. There are circumstances under which you can get extensions, or you might be able to go back and ask for a fee, but you need to explore those with your legal advisors and recognize the onus will be on you to demonstrate that you're entitled to that. As I said, the roles of processors and controllers are now clearly identified. Controllers have a legal obligation to ensure that any other organization processing their data on behalf of the controller does so only under the terms of a contract, and that the data is properly and securely managed throughout that, and that at the end of the processing contract, the processor returns the data to the controller. Where the public authority sees that it has an exemption from any one of the rules, then that's fine, but it needs to identify and document very specifically what those exemptions are and the basis on which it is relying on those exemptions, and those need to be built then into the training of the staff who are involved in dealing with consent or dealing with data subject access requests. Where you're relying on consent, that must be clear and affirmative. You have to be able to demonstrate that consent was given, and consent cannot be by default. It has to be by a positive action, and consent has to be in the light of a clear privacy notice that sets out explicitly what the intention is in relation to the processing of data, and which sets out what the rights of the data subject are. If you're dealing with special categories of data, what used to, under the Data Protection Act, be called special categories of data, or sorry, used to be called sensitive data, you need to have explicit consent to exactly what you're going to be doing with that data, otherwise it's prohibited from processing it. It's also necessary to get the authorization for processing personal data for anybody under the age of 16, unless there is a variation by a member state. Member states can vary anywhere between the age of 13 and 16, the point at which a minor can give legally consent to the processing of their data. If it's likely that you'll be collecting data from minors, you need to have a process in place that enables you to verify their age, and if they're getting consent from an authorized adult, to verify that that adult is in actual position to give that consent. I've touched on the requirement to secure information, and the security of personal data is paramount to demonstrating that you're meeting the rights and freedoms of natural persons. All communications with data subjects have to be clear, concise, intelligible, have to take account of the skills and abilities and competences of the data subject to interpret the information given to them, and as I said, this has to cover off what their rights and freedoms are and how they go about exercising their rights. It's still possible lawfully to get data other than from the data subject. You can get it from a third party, but Article 14 of GDPR sets out how you go about then telling the data subject where you got the data from and what you're now going to do about it. Articles 25 and the ones that follow set out the requirements around data protection by design and by default. And what that's really saying is that you can't hope that data security and data protection will be effective. You have to build it into the entire process. And because GDPR applies to existing data, the data that you're holding at the point GDPR applies on the 25th of May, you need to do an audit that identifies all of the data you're holding. You need to identify how it's being processed, which partners or contractors or suppliers or other organizations have access to that data. You need to put in place appropriate contracts with third parties. You need to make sure the privacy notices provided to citizens are appropriate to the processing that you're doing. And you may have to go back, having done a data audit, and build all of those compliance components into what you're doing. And it's a key area where talking to professional advisors, working, for instance, with Agilisys, looking at how you can tackle those is a key part of ensuring that you're going to be able to demonstrate through a very complex supply circumstance that you're in compliance with the privacy by design requirements. The security requirement is not a black and white tick box exercise. Accountability, again, is at the cornerstone of how you demonstrate compliance. You need to ensure that the security you put in place is appropriate to the risk. That means you need to have an effective method of identifying what the risk to rights and freedoms of data subjects will be. You need to link that up to your information security control activity, and you need to ensure that the measures you put in place deliver on the security objectives that you set. And measures like encryption, pseudonymization are techniques that you can use to limit the exposure of personal data. And certainly where data is either encrypted or pseudonymized, you've got a reasonable argument that says that where you're breached, you don't need to inform the Information Commissioner because you'll be able to argue that there is no risk to the rights and freedoms of data subjects under those circumstances. However, if data is encrypted but you're no longer able to access it because, for instance, you've been subject to a WannaCry attack and all your systems are not available to you until you find some way of getting out of it. The data is not available. That's still a data breach under GDPR, and it's a circumstance under which, in spite of the fact that data is encrypted, you will still have to notify the ICO that you've had a data breach. One of the vaguest terms in GDPR is the requirement to implement appropriate technical and organizational measures to ensure that what you're doing is in compliance with the regulation. It's up to you to determine what's appropriate. To do that, you're going to be looking at external guidance. You're going to be looking at external standards like ISO 27001 and BS 10012, both of which meet what GDPR sets out as being requirements for how standards should be written, structured, and used to enable organizations to demonstrate appropriate steps towards meeting their compliance obligations. The emerging codes of practice, management system certifications, and so on will all enable you to demonstrate that you've made appropriate steps to meet your obligations. And therefore, if and when there is a breach, and I think as we all now know with breaches, what one's talking about is if, not when, you'll be in a position to minimize any fines on the basis that you've taken appropriate steps. So, Brexit, its effect on data protection in the UK will have no effect at all. GDPR comes into force on the 25th of May 2018, irrespective of the fact that Britain is planning to leave, because at that point it will be still part of the European Union. In fact, both the Information Commissioner and the government have confirmed, and a piece of law, a piece of regulation to bring it into force are all part of current government planning. So it's going to happen, it's going to come into force after the end of March 2019, assuming that Brexit is complete. At that point, one has to work on the assumption that the UK will be a third country. It will be outside of the European Union. Therefore, all of the requirements around extraterritorial transfers will apply to the transfers of data from and to organizations inside the European Union and us inside the United Kingdom. So clearly the one problem is going to be that data subjects might bring an action, might bring a complaint to the Information Commissioner, or might bring an action in a UK court or in a foreign court claiming compensation for damages. The bigger issue is that you have to report breaches to the Information Commissioner. The obligation on a data controller, and the controller is defined as the organization which collects the data and determines the purposes for which it's collected. The controller has to report a breach within 72 hours of becoming aware of it. You should assume that if it takes you a couple of months to become aware of it, you will face questions as to why your systems are so inadequate that it took you that long. You should be aware of breaches very quickly. The challenge is not just in being aware of breaches, it's in putting together the very solid body of knowledge that is necessary to enable you to report. And the data breach is defined very clearly in GDPR as any interruption to the availability, confidentiality, or integrity of that information wherever it's being processed in the world, and that includes if it's being processed on your behalf by a processor under the terms of a legal contract. The processor has to report to you without delay. There's no exemptions, and while there are some circumstances under which you can determine not to notify the information commissioner, there are no circumstances under which the processor can avoid telling you. Where there is a high risk to the rights and freedoms of data subjects, you also have to go and tell the data subjects directly by whatever the most effective mechanism is. You need to tell them in clear and plain language, and the supervisory authority might, if they think that you're underplaying it, insist on you doing more than you were planning to. As I said, where you can demonstrate that there is no risk to rights and freedoms, or the risk to the right to the data subjects will not materialize, there's an arguable exemption from the reporting to data subjects directly. So what that all adds up to is an environment in which the Information Commissioner in the UK is the supervisory authority for the United Kingdom. The direct relationship is with the data controller, any local government or public authority, for instance, collecting data, and you've got duties to data subjects, individuals, the citizens, the non-citizens, whoever you're collecting data from, and they have rights, and those rights are a reflection of your duties. They go hand in hand. Where you outsource processing of data, you've got an obligation to ensure that it's secure. If it goes to a third country, you've got an obligation to ensure that it does so lawfully. And there are going to be issues, particularly for public authorities, around disclosure and what's lawful disclosure and what isn't. Each of those are areas under which you could find yourself dealing with a data breach. And so data protection officers have got a pretty pivotal role for public authorities in dealing with data breaches. As I've said, there are three circumstances under which appointing a DPO is mandatory. That includes the circumstances for not just being a public authority, but also when you're processing high volumes of personal data or high volumes of sensitive data. Those are both circumstances under which it's necessary to appoint a data protection officer. And the role of the data protection officer, most public authorities are going to already have somebody doing this kind of a role, but the role has become significantly enhanced, becomes a much more important role for organizations. So, mandatory. You don't have to. Smaller public authorities, it might not be something you can afford to have a DPO entirely for yourself. GDPR allows for a DPO to be appointed to a number of public authorities, or a public authority can appoint a DPO for each of the separate entities within the local authority. For instance, you could have a DPO who looks after housing, but who's also the DPO for some other parts of the council. There are all different ways you could put it together, but each entity, each data controller will need to have a data protection officer. As I said, it's a different role from what it was. It's now a protected position. The data protection officer can't be dismissed. Their employment contract cannot be terminated because you don't like the advice they're giving you. They have to be appropriately qualified, and appropriately qualified means quite clearly two things. The first is a good understanding of data protection and privacy law, which might come from a legal background or legal training, but GDPR is a law, and so the requirement is that DPOs have a solid understanding of the law. But there's also a requirement they understand how the law would be implemented, so a good grasp and understanding around the issues of data security, around documentation, around process management, and how all of those should actually work. And an appropriately qualified and experienced DPO must, by law, be consulted in respect of all data processing activities. Outside of those areas where it's a mandatory appointment, it's a good practice one, it's difficult for us to imagine circumstances under which an organization won't, at the very least, have a part-time contracted data protection officer providing minimum guidance. The range of fines and the complications of data subject lawsuits are so substantial that not having proper support doesn't make good sense. So, data protection officer, but you need more than a data protection officer. You need to build an understanding of data protection compliance, GDPR compliance, right the way through the organization. Anybody dealing with personal data needs to understand what's necessary, and that includes your own internal HR, legal advisors, as well as everybody dealing with the general public, with whoever it is that you exist to serve. Basic training for staff awareness training, compliance training, all of that needs to be a key part of how you deal with GDPR. And there are very good externally accredited practitioner training courses available. They're logical routes for you to go in terms of making sure that your data protection officers, and when you're taking an existing person who's provides a data protection officer service internally who has that role, and they need to be retrained to meet their requirements for GDPR. A good GDPR practitioner training course is the logical place for them to go to acquire those skills. We're just having a
it's just worth, I think, just pausing on DPO. So there's a question that I've certainly been asked by local authorities about whether roles such as the head of IT or the head of legal can take over this role. Is that appropriate?
It's a good question. The logic is that it's a good question. The logic is that the data protection officer should not be conflicted by any other roles, and GDPR is explicit in saying that the data protection officer has to be able to give advice without having any other issues they've got to deal with. So it would be inappropriate, probably illegal, for a head of IT who's got delivery responsibilities and whose role will give them the need to make decisions about how data is collected and processed, for them also to be a data protection officer, because it's very difficult for them to give themselves the appropriate level of independent advice. So yes, I think the head of IT is unlikely to be suitable. Head of legal could be, if the head of legal is able to provide independent advice to the council or senior management of the organization. That's pretty critical part of the role.
And just from given that the data protection office is pretty well the heart of the data protection culture in an organisation, with GDPR coming in, there's going to be, I guess, a call for investment in potentially technology. Would you think it would be appropriate that the responsibility for that investment should come under the DPO, or should it come under the IT manager or IT director, perhaps?
And again, I think that's a very good question. There are clear challenges in whoever takes on the role of determining what software to deploy, because if you're going to stick with the requirements that the DPO has to be independent, the existence of a budget which says this is the only amount of money you can spend on software to put compliance in place might limit the extent to which the organization is compliant, and that instantly conflicts the DPO. They're spending not enough to achieve compliance. And I think the reality is every organization is going to have to tackle this for themselves. In practice, it's probably going to be the case, the sensible position is probably going to be that DPOs will continue to provide advice and guidance, and heads of IT will be responsible for buying and deploying the software that enables them to manage the data of citizens throughout the organization. Where there's specific software that's tracking compliance or collecting information about levels of compliance, yes, possibly that might be without a conflict under the control or direction of the DPO.
Okay, great. I've had to change laptops sort of whilst you were talking there midway, so if I could ask you to move the slides on, as I haven't got control here at the moment. So I thought the next what we want to cover off is just some of the more practical impacts for local government. So if we can flick on to the next slide. So, so just working from left to right here, so there's a clear need to educate your staff as to what constitutes personal data in your organisation and what does not. The world's changed, as Alan said. We now need to include biometric, genetic data, and even IP data. Can be considered personal data if you can put it with other data and identify someone. I think also much has been said about doing a data audit. It is important, but obviously bear in mind that that's just a snapshot. In this digital age, you'll probably be wanting to consider possibly how technology can help you ensure that you can constantly identify where your organisation is holding personal data, who's got access to it, and what they're doing with it. The next box, certainly greater need for transparency of personal data held, why you're holding it, how long we hold it for. If you like, this is really a requirement to provide the evidence, and if the ICO, the supervisory authority in the UK, comes knocking on the door, you want to be able to give them that pack of evidence to say, yeah, you know, we've done everything we need to in compliance with the regulation. Now, I suspect most organisations will have things like retention policies sitting on the shelf. Well, now they need dusting off and they need aligning directly with the personal data to which it relates. And you know, you probably want to start focusing on the value that you are going to get from holding that personal data, because you're going to have to jump through hoops to properly collect it, store it, process it with the demands that the GDPR makes. Thirdly here, local authorities currently rely on legitimate interest as the lawful basis for processing personal data, more than consent. On the GDPR that changes, and I believe, Alan, that the UK government is able to adapt the rule here, but has there been progress on this one?
Progress, the UK government appears to be slightly preoccupied with a number of other issues, but the basis for the lawful basis for processing data is certainly an area in which the government can make final decisions about how public authorities can do that, and it's a key area for public authorities to pay attention to, yes.
Okay. And then the final one here is consent, where it is used in local authority. It's got to be given by the citizen, and if it's used as a legal basis, it's not going to be permanent. It can be withdrawn, and is obviously only provided for specific purposes. And in practical terms, authorities may need to look at the systems and processes they have so that these rights can be supported. And again, you can prove that you asked for consent and it's being used for it's being applied to the data in the appropriate way. So it may be necessary to reconsent people where you have used that as the lawful basis. So this is, again, an area that needs investigation for your particular organisation. If we go on to the next slide, privacy notices. So these long documents, they've often been full of legalese, have got to change. They need to be more user-friendly, more understandable by the subjects. You can have a look at Twitter. They've just released their new privacy notice. It's still quite a few pages long, but they have tried to make it easier to read. But again, for your organisations, privacy notices are going to need to be front and centre, and some practical effort to go and look at what do you need to say to people and at what time, as far as the privacy notice is concerned. Data controllers are not going to need to be registered with the ICO anymore, so that's, I guess, a small administrative benefit, but now you need to keep your compliance documented and up to date. So those decisions that you took, perhaps not to invest in encryption, they may well be appropriate, but you need to document that you took that decision and evidence that you took the reasons you took it and that you believe that they are appropriate measures. You've basically got to show that you've proactively tried appropriately comply with the regulation in good faith. Lots of vague terms in there, I guess, which will have your legal teams working extensively, no doubt. Next one on subject access requests. So I forget, let me go back to the slide there. Yeah, subject access requests. We have to deal with these today anyway. Now, technically you can charge for it, but from May next year, those requests will be, in most cases, free. And I think with all the media coverage, it's not going to be inconceivable that you'll see an increase in people looking to exercise their access rights. And again, in practical terms, you need to look at your processes for supporting those requests. And this is certainly one area where you may want to look at integrated technology solutions, perhaps such as self-service, which could help remove the administrative burden. And also, it wouldn't be unhelpful to your reputation for putting the customer or citizen first. There are other rights too, including erasure, which, in case if you're wondering, does mean that personal data held on backups is in scope here. So again, you'll need to establish processes to identify, isolate the data, and then understand whether you can exercise the subject's rights, unless, of course, you object, in which case your staff will still need to understand the specifics of when to erase and when to not. And that's just one right. So if you go on to the next slide. So we've talked about breaches, but notification to the ICO, the UK's body, will be required in certain circumstances. The wait and see if we get caught. Let's just not mention that lost unencrypted laptop and then pray to the sun god that only a nice person finds it and doesn't want to exploit the data on it, or let the ICO know for you. Well, that one isn't going to wash. If you do withhold a notifiable breach and it comes to light, well, you probably want to get your checkbooks out for the fine. So in practical terms, you'll want to be looking at your breach processes in your organisation and with your IT partners, PR team if you have them, legal and exec teams, and you'll probably want to rethink how you currently detect breaches, because as we talked about, the fines could be quite devastating. Data Protection Officer, the DPO, we talked about that earlier. Suddenly the DPO is going to be in the limelight, certainly from May. They are going to be front and centre. And the GDPR is going to encourage you to make sure the DPO has got sufficient support and resources. And again, if the ICO comes knocking, they'll be looking at what support you provided to your DPO. Data protection by design and by default. I'm really pleased this is coming in. This really puts a lens on how we are developing new services and how they are consuming personal data. And again, in practical terms, it's all about evidence, documents, showing that you understand the data flows and the risks to the rights and freedoms of the subject if that data is lost or misused, or perhaps can't be erased in the 30 days, or it can't be erased immediately because it's only required for a short period. And then finally, the big stick of the fines and the resulting impact on the reputation. And I think if I was the ICO, I'd be looking for a high-profile organisation to make an example of pretty soon after May next year. Local authorities would fit the bill quite nicely. So if this isn't on your boardroom agenda as a corporate risk item, I hope it is after this webinar. And then just some small print at the bottom there. Many authorities will have contracts with data processors, service providers. You'll want to be reviewing these, making sure that the processors and providers are helping you with recording compliance and providing statements of appropriate security, for example, for personal data. And you'll also want to work with them to make sure that privacy risk is being appropriately managed. So if we go on to the next slide. So GDPR is after it's a sustainable change. You can blame the acronym here and the facts that it is a data protection regulation, but who normally takes care of data protection? CIO, CSO? It's different this time. So GDPR massively impacts the day-to-day operations of anything that has to do with EU citizens' personal data. Being indifferent or loading this onto your DPO solely is not going to be sufficient, I'd suggest. You definitely need board level sponsorship and engagement to comply with this. And I think if you really want to drive change, GDPR needs to be a cultural change program right across technology, process, people, and the supply chain elements, which is what you would expect of a transformation. So how and what are the steps to do this? We go on to the next slide here. Well, step one is not to put your head in the ground until May and rely on the compliance that you already have. The "we've got it covered" response is not going to wash. Alan, what are the proactive steps that we need to take here?
So the ICO has published a set of guidance on what steps to take, but from a practical point of view, they're not actually steps, they're just areas you need to address. And so over the last 9 months working with clients in public and private sector, what we've done is put together something which we've tested now multiple times with clients as a set of steps which you can take one after another. As time gets short, you need to take them quite quickly one after another, but which lead through, they incorporate the areas identified by the ICO, but which lead through to the point where you can begin to have some hope that you're coming into compliance with GDPR. And the starting point is a governance framework. The size of the fines, the impact on the organization is such that your council, your board, your senior management need to put themselves in a position where they can be clear that GDPR is being properly addressed throughout the organization. So there needs to be awareness at the top management or council level. There needs to be a sponsoring individual who owns and who talks and who supports the program. It should be part of the corporate risk register. The possibility of a significant fine should be on the corporate risk register. It's a very real risk. You just have to look at the range of cyber breaches there have been just in the last 3 or 4 weeks around the world to recognize that cyber risk is a real risk for every single organization. Accountability is at the heart of GDPR, so how does the framework, the accountability framework, operate? How does it flow through from the board, through the organization? How do we set out clearly roles and responsibilities? How does senior management review progress towards achieving GDPR? What are the program steps? What does compliance look like? All of those need to be worked out and put in place. And you need to have, if you don't already, a very clearly thought out program, and this is a traditionally defined program, a series of interlinked projects which will lead you to something that looks like compliance by the given date and on which the board or council is getting regular progress reports. You have to have a data protection officer. And if you don't, you should have, so get somebody in place, make sure that he or she has adequate training, make sure that there are adequate resources in place, and that means probably a team of people, it means time and money, it means access probably to external support and training. You're not going to be able to justify reducing a 20 million euro fine by saying we didn't think we should spend a couple of £1,000 on getting appropriate training for our data protection officer. If necessary, share your DPO, bring in an external DPO, but just make sure you have them and make sure that they've got appropriate resources to tackle what they need to do. The third step is to determine what data you hold. You can't get data compliant if you don't know what it is. So you do a data inventory, work out any third-party processes that are dealing with data on your behalf, get clear about the contracts that are in place, work out with partners, identify any what we call shadow IT, personal data which is being collected and processed inside the organization that you don't know about, lists of contacts, personal data held on, personal data, in other words, friends and relatives held on authority systems you could probably legitimately and sensibly treat as data that you're responsible for. Work with your partners to make sure that you've identified any personal data being collected or processed. Processing, bear in mind, the definition of processing includes just looking at data is processing. It's not the technical manipulation. It includes looking at, assessing it, reorganizing it. All of that falls under the definition of processing. If necessary, use one or more data discovery tools, but make sure your inventory process is sustainable. You want to be able to track how your data changes and where it's held and who has access to it changes and adapts as the project progresses. And the data inventory links into the fourth stage, which really is a data flow audit. How does the data come into your data bases, what's the basis on which you've told data subjects you're collecting the data, how are you protecting the data through each of those stages, and your data protection officer, who should really be involved in each of these stages, will almost certainly need a team to help identify how that data is flowing. You might need to work with outside providers, technology providers, to make sure you've understood what's happening with data, what protections are given to it. Remember that paper cabinets, paper archives are all in scope. You'll have noticed there was a recent fine that related to substantial numbers of out-of-date paper documents. Everything that includes data in a structured filing system is subject to GDPR. So look at how you're managing that data, look at how the various software and physical assets consume and use personal data, and make sure you identify with the information security management team what security controls you have in place in relation to that data, and whether or not those controls are effective. Once you know something about what data you've got and how secure it is, you can begin looking at the extent to which your processing of the data is compliant to the requirements of GDPR. So step 5 really is to do a detailed compliance gap analysis. Many organizations, just to be clear, will do a very high-level gap analysis at the start of a project in order to structure and aim how they go about it, and then do a detailed compliance gap analysis, having identified what data you're holding. This is where you can make sure that your privacy notices in respect of all of the processings are robust and correct, that the lawful basis of processing is accurate, that your intended data retention period is clear, and that you're not holding data beyond the point at which you should be holding it. You've got subject access request documentation in place, and you can create what Article 30 calls a record of processing, the description of what data you're processing, the purposes for which you're processing it, and how and where you're processing it. A data protection impact assessment, a DPIA, is mandatory for the processes which involve high volumes of personal data or high volumes of sensitive or special categories of data, or which involve processing data of data subjects in a large scale in the public space. So CCTV in a housing estate or in some other environment would be caught by the mandatory nature of DPIAs, and the Information Commissioner has a legal obligation to publish a list of processes for which a DPIA will be mandatory. So you need to work out if you're on that list. If you're not and you think you should be, don't delay, still do a DPIA. And in fact, for most processing of data, a DPIA is still a sensible thing to be doing. And this is just 1 or 2 records. Any high volumes of data, if you want to be able to demonstrate that you've tackled the requirements for data protection by design and by default, the only real way you can do that is by starting with the data protection impact assessment, the mapping of data flows, the assessment of the extent to which those data flows can be undermined, or the confidentiality, integrity, or availability of that data can be compromised. Step 7 is to remediate. Put in place whatever documentation and controls you need to put in place to ensure that you're able to comply with GDPR. What we call the creation of a privacy compliance framework, which ties together the governance, risk and compliance aspects, what the board's expected to do, the personal information management system that deals with documentation around personal data, and demonstration of compliance to the specific requirements of the 6 data protection principles. At the very least, you should be thinking about getting Cyber Essentials and probably Cyber Essentials Plus in respect of each of the entities that's processing personal data. They're government-mandated independent certificates that demonstrate that you've got in place security controls adequate to deal with most common standard internet-borne threats. ISO 27001 is a logical next step as organizations mature. You must have a data breach response process. You must know how to identify security incidents, how to escalate them, how to report to the supervisory authority. All of that's critical because you've got just 72 hours in which to do it. So developing a process, testing it, doing simulated exercises, all of it's fundamental to making sure that when there is a breach, you're going to be able to report. And of course, finally, make sure that it works. Monitor, audit, continually improve. You need to have, as part of your ongoing audit process, the auditing of GDPR and security compliance, your incident response processes. The whole of your privacy compliance framework, in fact, should be subject to your monitoring and auditing processes. So that's what you need to do. What does the ICO have to say to encourage you? Well, what they say is we think there are real good advantages for organizations in terms of demonstrating to citizens, data subjects, customers, what a good job they're doing around data. But hey, if you don't want to do that, we've got some really nice big sticks. We've demonstrated that in the UK, we're very happy to use the sticks to the fullest extent that we can. When you look around Europe, where the capability for issuing fines is very much greater than currently in the UK, you'll see that the UK has an opportunity to demonstrate that it too can levy very substantial fines. They're not afraid to use it. They're able to levy fines up to 20 million euros, and they're very clear that they're not going to use those powers just for typical data breaches. They're going to use them for areas where organizations' accountability has failed, where they've failed in terms of the requirements around data protection by design and by default. DPIAs should have been done, inadequate documentation. In fact, where data protection isn't a cornerstone of how the organization operates, then you can expect the opportunity to give large chunks of money to the general fund for data protection fines. Got to be a fundamental part of the organization's culture. There are a whole lot of materials available for organizations to use in addressing their requirements. You can do this on a self-help basis. You can get pocket guides and implementation manuals, documentation toolkits, gap assessment tools. They're all tools which you can use on your own with your own competent people to tackle GDPR compliance. You can get the pocket guide delivered in an organizational branded version so that you can share it internally amongst all the staff. You can add in particular components that you want to tell your own staff what they need to be able to do. There is very good externally formally accredited training courses, both at a foundation level and at a practitioner level, which are delivered online, in a classroom or through distance learning. They're also very good mechanisms for ensuring that not just your data protection officer, but everybody involved in the GDPR implementation team have the skills that they need. In the public sector, you probably already have competence around how to do privacy impact assessments. The requirements of GDPR are more extensive, but nevertheless, you can build on what you've got. A DPIA workshop is another way in which you can ensure that you've got the skills necessary to take that ahead. If you look at the timetable you've got to compliance, the 227 business days and reducing, and you say, gosh, we need help, then of course there are a number of external support options available, from gap analysis, data flow audits, consultancy who can help implement personal information systems, information security management systems, or simply do cyber health checks, which will tell you in relation to all of the organization's processes and specifically in relation to personal data, the state that you are in terms of cybersecurity. So there's a significant range of information available and tools and support available that can help you tackle this. Specifically for local government, consultants like Agilisys working with IT governance can support your data protection officer, your information security manager, head of legal in creating the policies, processes, and technology platforms that you need to achieve a sustainable and compliant environment that enables you to demonstrate ongoing compliance with GDPR. And as I said, while 25th of May is the target date, the reality is most organizations are not going to be perfectly compliant by then. You need to be moving as fast as you can, because the moment that there is an action brought against you in a court or a complaint to the Information Commissioner, you can assume the Information Commissioner will come to do an investigation. Your partners, again, Agilisys, for instance, data protection officer, team DPO, data protection specialists can help think about how to support your own program and project managers in making sure that what you're doing is taking forward the process of achieving GDPR compliance. And so transformation@agilisys.co.uk is the email address that enables you to access that range of services and support to help you address GDPR compliance. And please do stay out of trouble. There's much better things for your money to be used for than simply paying substantial GDPR fines.
Thanks, Alan. There's kind of no real reason, excuse for organisations or suppliers to be ignoring GDPR now or putting it lower down on the priority list. Thanks, Alan. Have we still got time for questions?
I think technically not, but I think as there are people who are here and probably have questions to answer, it's probably worth taking the first few and then answering all the rest of them electronically, as we've often done in the past, so that everybody sees the questions and answers perhaps over the next day or two.
Shall I pick out a couple here? So there's one, the first one I got from James Walker. Can you clarify, is the movement of personal data within the EU restricted by GDPR or supported by it?
So the simple answer to that is that GDPR says personal data should be able to move anywhere inside the European Union, and data subjects should have exactly the same rights wherever their data is being processed. So somebody in Germany should be entitled to have the same rights to data portability from a supplier in the United Kingdom as vice versa. So it really does support free movement of personal data and a level playing field across the European Union.
Okay, and a quick one here of Stephanie Crosby. She said, we've been led to understand that a business email address or phone number is not personal as such, as it is for business use and widely available online. So does that fall under the GDPR?
It certainly does fall under GDPR. It was an interpretation of the legislation that said business contact data wasn't personal data under the Data Protection Act. It was arguable then, it's not arguable now. Anything that enables a person to be identified, irrespective of whether it's a business email address or a personal one, is personal data and therefore protected under GDPR. And frankly, even if somebody has published their email address online, that doesn't mean that you're entitled to take a copy of it and use it without telling them, because when they published their email address, it wasn't necessarily for you to use it. And so GDPR explicitly, and Article 14 deals with it, says you'll still need to contact somebody where you've got their data other than from them and tell them what you intend to do with their data.
Okay, and it's a good one here, I think, just around the practical elements of this. How do you deal with stakeholders not giving you enough support in implementing GDPR?
The simple answer is to resign and go and work somewhere else. Because I was going to say, because in practical terms, the stakeholders won't. If you're the DPO, you have to say very clearly, you're in breach, you will be in breach. I'm not going to have any option as an independent advisor to you, but probably to inform the Information Commissioner that I'm your DPO, but you're failing to comply with your obligations. And in extremis, I can't work here.
That's and full stop. So,
yeah.
I mean, from a practical perspective, it's about engaging the board and having a senior sponsor with this. It isn't just the head of IT or the DPO on their own doing this. They've got to get
exactly right.
board executive engagement in driving this forward. It's got to be on the boardroom agenda on a monthly basis.
Absolutely right.
And just one final one. So it says, how will a GDPR expert help the local authority prioritise their risk, and with what software?
Well, I think the simple answer is that it will depend on the local authority. It will depend on which elements of the local authority. It will depend on which data. It will depend on the extent to which they're currently Data Protection Act compliant and the extent to which they want to use what software. So the typical starting point is that a consultant will sit down with a local authority and identify each of the entities that's within scope, identify working through a fairly straightforward gap analysis tool, looking at those 9 steps that I was outlining, exactly where the major issues will be, and from that put together a prioritized action plan to address those areas of the project.
Okay, so I think we've probably just got to the end of the time here. We will respond to the other questions that we haven't got to. So I'd just like to say thank you all for your time. I hope this webinar has been useful for you. Please don't forget forget to get in contact if your organisation needs help as time is running out. And last thing for me to say is thank you and good luck with your GDPR compliance programme.
Bye-bye.